Ladies and gentlemen, if I could have your attention, please. Thanks, ladies and gentlemen. We'll now begin the evening. My role is really just to tell you about how this evening is going to operate. First, we're going to hear from some learned friends ruminating on the themes from the classic movie, The Castle. After they do so, there'll be a brief opportunity to get a refreshment, which are all up the back. There's a little lollybag station, so you can get ready for the movie screening. And then there'll be, after about 15 minutes, grab your drinks, take a seat, and we'll get the movie going. I'd also like to acknowledge all our sponsors tonight. So King & Wood Mallesons have put on the spectacular venue. Our principal sponsors are Timpano Legal, and I'll speak more about them very shortly. We've got to thank Cullen MacLeod for putting on the Cullen wines up the back, Gage Roads for putting on the beers, and our sponsors throughout many of our events, KBE, Chris Bates is in the back of the room, and Pitcher Partners, and Tim Martino is also in the room tonight. So without any further ado, I'd like to introduce the principal of Timpano Legal, Laura Willocks.
Thanks, Nick. I'm also joined tonight by other members of my team at Timpano Legal, Alex Mossop, Arena Mundy and Sarah Jessup. I'm very happy to be sponsoring tonight's event and very grateful to our eminent speakers for showing their support to a CPD event with a little bit of difference. I think it's great that the law and arts have combined tonight to offer us something a little bit different rather than a totally black letter law CPD, and we have Nick to thank for that. Tonight it's my job to introduce Thomas Percy QC. Now he requires little introduction, but just let me give you a quick few facts. He was admitted to the bar in 1978 and became Queen's Counsel in 1997. I wanted to place some relevance tonight between Tom and the movie The Castle, and I was reminded of a quote from the movie today of when Mrs. Kerrigan was asking the QC what a QC was, and the QC said to her, "Oh, that's Queen's Counsel," and she says, "Oh, do you counsel the Queen?" And Mr. Kerrigan says, "Oh no, they're the lawyers. They're lawyers for rich people, love." Well, whilst that might be true in some or most circumstances, Tom tends to put the lie in that suggestion, as he often is the lawyer that acts for poor people. And there probably is no one better qualified to speak about the underdog and the law. So, ladies and gentlemen, I welcome Mr. Percy.
Thanks, Laura. Thanks for having us along here tonight, Nick. Thanks, everyone, for coming. The movie The Castle has been a favourite of mine for many years, and it embodies three of my most cherished topics: lawyers, bogans, and greyhounds. The law and bogans, of course, are inextricably mixed. A colleague of mine was recently telling me about a case she had where the client was, quote, a real bogan, unquote. Because my response was that I didn't think I'd ever had a case where the client wasn't. Greyhounds are admittedly an unlikely leg of the trifecta, and I wouldn't propose to dwell on their contribution to the film at any length because they've had their share of unfortunate publicity in the past month or so. But if lawyers and bogans are the subject of the film, what we might ask is the theme. Well, the theme, of course, is the underdog. And it's a concept close to the heart of most Australians, I suspect, with the possible exception of Tony Abbott and Joe Hockey. And it's a title that politicians vie for at each election. You see them every time. We want the underdog status. We want to go in as underdogs. And it's the title that footy coaches vie for before games like the Grand Final or the Western Derby. Well, it's probably fair to say that in recent times the West Coast deservedly seem to have a mortgage on that one. The underdog is the horse that you look for in the Melbourne Cup. The battling bush trainer and jockey hoping somehow to overcome the might of the millionaire Arabian sheiks and the Japanese billionaires. possibly because it's more romantic to win as the outsider. The greater the challenge, the greater the glory, perhaps. But possibly the Australian obsession with the underdog is more driven by the fact that if you go into any particular event as favourite, you're on a hiding to nothing. If you win, it's expected. You lose, and you're an epic failure. The underdog, on the other hand, has little to lose. You win, you're amazing, a hero. You lose, and it's enough that you put up a pretty gallant fight. Underdog status is, a cynic might say, simply a means of making losing acceptable. But of course, in the classics, like this film, the underdog rarely loses, which is sadly somewhat divorced from the judicial system. In art and literature, and usually in the newspapers, the best story is always, well, almost always, the underdog beating the odds. The unlikely, the lowly born, the disadvantaged, emerging triumphant. And since David and Goliath fought it out in the book of Samuel back in about 500 BC, there's been a certain attraction in literature to the underdog. One which I perceive has continued to prosper in literature through the ages. John Milton, of course, was an early pioneer of the concept in his masterpiece Paradise Lost, which I'm sure all of you have read, in 1670. Although those of you who have read it will recall the underdog in that work was actually Satan, so the genre still needed a bit of tweaking. Charles Dickens painstakingly took on the task of the underdog in literature in books like Oliver Twist, Bleak House, maybe David Copperfield, and Charlotte and Emily Bronte around the same stage follow suit with underdog works such as Jane Eyre and, of course, people like Heathcliff in Wuthering Heights in the 1840s. And you probably all are familiar with the works of John Steinbeck in the 30s in America, who perfected the genre in epics like Of Mice and Men, The Grapes of Wrath, and gradually the theme was perpetuated throughout the 20th century. Even series like Tolkien and The Hobbit seek after that particular aspect of the theme. More recently, it endures even in literature such as Harry Potter, and more recently Game of Thrones. You might imagine there probably never been more classic underdogs than Jon Snow and Tyrion Lannister. And ironically, the film The Castle is somewhat of an underdog itself. It cost only $750,000 to make. It was completely written and made in about 7 weeks. And against those humble beginnings, it grossed an unlikely $10 million in its first year at the box office. But perhaps what makes the film so engaging for us as lawyers, other than ourselves being essentially the subject of the matter, is that we daily engage in the game of underdog ourselves. It is, in a way, our culture. From the plaintiff quadriplegic taking on the might of the multinational insurance company right through to the wrongfully accused defendant battling against the might of the state and the limitless resources of the DPP or the tax department, God forbid. It's part of our professional lives. The question, however, as to who exactly might be the underdog in any given case is often a matter of perception rather than objective fact. In the late 80s and early 90s, if any of you here are old enough to remember them, which I doubt, there was a popular view in some quarters, particularly the press, that it was the prosecution who enjoyed the underdog status. Cases like Laurie Connell and Alan Bond, the committal proceedings and the trials, the defence often mounted massive defence teams, bigger than I even have, which sometimes included multiple eastern states and local silk. Several juniors, solicitors, paralegals, clerks, you name it. They had a footy team of people come down, whereas the prosecutor was on a fairly modest representational basis. It often gave the impression of a David and Goliath fight in favour of the accused. where the accused was actually the Goliath. Whether that was more the perception than the reality is probably a matter of conjecture, but I suppose one thing we need not lose sight of is that most of those accused, ironically, were convicted. Whatever the situation may be, there is no escaping the enormity of the task facing an accused in any serious criminal prosecution these days. For example, if the prosecution want to call a witness to testify in person from wherever, they just issue the subpoena, write the cheque for the airfares and expenses, and he's here. If they want to call the world's foremost expert, they do it. Or brief Australia's top silk, which they did in cases like Mallard and Rainey. They just do it. Not so easy for the middle class mortgage belt accused who's usually mortgaging their home to fund a modest defence. Of course, the advent of evidence by video links made it easier to overcome those sorts of obstacles relating to witnesses and somewhat levelled the playing field. But the exigencies of any given trial are undoubtedly still stacked against an accused person. If Sportingbet, Ladbrokes or Tom Waterhouse were allowed to open an agency in the foyer of the Central Law Courts to lay the odds on the outcome of any given jury trial, I suspect I know who would generally start favourite. Now, the other significant aspect of inherent unfairness in the system, in my view, is the absence of any costs for an accused person. You get them in the magistrate's court, have done for 50-odd years. So why not in jury trials? To be acquitted as a privately funded accused, only to leave the court with your finances, not to mention your reputation, in tatters as a result, is simply and utterly unjust. Sadly, an acquittal in WA in major jury trials remains merely a Pyrrhic victory at best. And when I put this to the Attorney-General some time back, he suggested to me that the anomaly was probably best cured by removing the right to costs in magistrates' courts. Work that one out if you can. This blight on our system remains a matter of profound shame and embarrassment for the profession, as does the fact that neither the Law Society, the DPP or the WA Bar Association seem to be currently taking any steps to correct the situation. But putting grim reality aside, if we can, on a night like this, the best ending, of course, for any book or movie is always when the little guy wins. Not that that happens much in life, whether in the court or in society at large. Sadly, and probably more often than it should, injustice prevails. As many of you here, I suspect, who may work at Legal Aid or the ALS or something like that, can readily attest. But mercifully, in the castle, against formidable odds, there is a happy ending. The castle is an inspiring story, particularly for those of us who do or have worked at the miserable coalface of the criminal law, with limited resources, bogan clients and greyhounds. For all of us here tonight, from the most senior silk through to the Dennis Denutos amongst you, and I'm sure there's a couple of you here, the castle has a message. If you keep trying, you never know what might happen, and that sometimes, just sometimes, justice might prevail.
Thank you very much, Tom. Ladies and gentlemen, my name is Alex Mossop. I'm also a representative of Timpano Legal, and I have the pleasure of introducing this evening's second speaker. Just to touch on one thing that Tom mentioned, the Dennis Denuto character. I'm firmly of the view that there's a Dennis Denuto in every lawyer, to some extent. I tend to find myself thinking that when I find myself swearing at the photocopier, which tends to happen most days of the week. Stephen Davies SC is the chair of Francis Burt Chambers and a barrister practising in all areas of commercial and civil litigation. He practices in particular in the areas of contractual disputes, professional negligence claims, equity and trust, corporation matters, construction and engineering disputes, trade practices and defamation. Between 1990 and 1998, he practiced in commercial litigation at Blake Dawson Waldron, as it was then known, and between 1998 and 1999, he practiced as a prosecutor at the Office of the Commonwealth Director of Public Prosecutions. In 1999, he joined the bar and took silk in 2009. He's included in the best lawyers in Australia in the practice area of litigation, and he's also been consistently generous with his time in teaching members of the younger members of the profession in the art of advocacy. Ladies and gentlemen, Mr. Stephen Davies, SC.
Thank you for that very generous introduction. I've been asked to say a few words on the expression on just terms, and as we all know, that's a reference to the acquisition power in the Commonwealth Constitution. The starting place, I think, is the full terms of the acquisition power, and the full terms are these. The Parliament shall, subject to this Constitution, have power to make laws with respect to the acquisition of property on just terms from any state or person for any purpose in respect of which the Parliament has power to make laws. Now, I expect that most of us have seen the movie that's about to be screened. It is a classic. It is of the genre of films depicting how uplifting and satisfying it can be to practice as a lawyer, and it is, of course, a work of fiction. The way in which the appellant's case is put in the High Court in the movie is that the expression just terms meant that the Kerrigan's house could not be acquired merely for a payment of money, because that would not be just because of the sentimental attachment that the Kerrigans had to the house. And the way in which that was put in submissions in the High Court by the Bud Tingwell character, Hamill QC, was this. He said this in submissions. You may think our appeal is based on emotion rather than law. Not true. It is about the highest law in this country, the Constitution, and one phrase within it, on just terms. That's what this is all about, being just. They want to pay only for the home, but they're taking away more than that, so much more. Sure, the Kerrigans built a house, then they built a home and family. You can acquire a house, but you can't acquire a home, because a home is not built of bricks and mortar, but love and memories. You can't pay for it, and you're only shortchanging people if you try. I can't speak for those who wrote this document, but I'll bet that when they put in the phrase on just terms, they hope to stop anyone shortchanging someone like Darryl Kerrigan. Now, the submission therefore was to the effect that the drafters of the Constitution had a much broader interpretation of the phrase on just terms than simple financial compensation. And what the drafters had in mind would encompass the strong sentimental attachment that the Kerrigans had to their house. Now, despite the fact that this argument seemed to find favour in the High Court in the film, that is not a construction of the provision that has ever found favour in real life. And I'm going to turn now to the real life construction of the power. In the time available, I think there are four interesting observations that can be made about the acquisition power. The first is that ordinarily a sovereign state will have an unfettered expropriation power, and that's because that power is common to all sovereign states on the basis that the sovereign has domain over all of the territory and all of the subjects of the sovereign. The reason why in Australia, in relation to the Commonwealth, the power is fettered by the requirement of just terms is because of the origin of the federation as separate states coming together to form a federation, and the concern at that time that the Commonwealth would have power to expropriate the property of the states. And that's the origin of the just terms feta on the acquisition power in the Commonwealth Constitution. But for that provision, it's overwhelmingly likely that whatever else was in the Constitution, it would have been interpreted as having the Commonwealth would have been interpreted as having an unfettered acquisition power to acquire property without compensation. The second, I think, interesting observation about the power itself is that it is, in fact, the acquisition power is actually conditioned on there being just terms. So when you look at any Act of Parliament, the inclusion in the Act of just terms is an essential part of the power. And an absence of there being just terms in the Act will invalidate the particular law. So if the terms of the relevant Act are not just, the whole of the law fails for lack of a constitutional prerequisite. The court dealing with the matter will not merely sanction the acquisition and then modify the terms. The result is that the Act itself is invalid. The third interesting point, I think, to notice is that the formulation of the provision concerns acquisition, either by the Commonwealth, its agencies, or by some person other than the person who holds the property. So the focus, and it's an important thing to notice, is on acquisition. That is different from the notion of property being taken but not acquired. So, for example, circumstances where a property right is destroyed or restricted without anyone acquiring anything, that is not the subject of this particular provision. And that's to be contrasted with the, I suppose, broadly equivalent provision in the US Constitution by the Fifth Amendment that concerns the taking of property. So when you look at the way our Constitution works, it's necessary to find an acquisition, not merely a taking of the property. The fourth matter to notice is that the provision requires just terms, and that is not necessarily the same as the notion of compensation. First, in assessing what is just terms, regard can be had to the interests of the community generally. So that is to say, the acquiring community, the tax-paying community, in working out what is just terms. And secondly, so long as the Act provides essentially a true attempt to impose fair and just standards of compensation, that will be just terms. Whether or not it leads to, if you like, an outcome of justice in the particular case. So the test is not about whether the terms lead to or mete out justice in the particular case. It's about whether the Act has a framework of just terms. Now, that last point serves to illustrate that we are about to watch a work of fiction, because the case will never be about, one of these cases will never be about whether or not a particular outcome is fair or metes out justice for a particular person. And in fact, it's hard to conceive that in real life any legislation that empowered a Commonwealth agency to acquire property for an airport would not meet the just terms requirement, whether or not that meted out justice to the Kerrigans in this particular case. But it is, after all, the movies, and we can all sit back and enjoy the fantasy of working to fight for justice for an underdog, which Tom's been telling us about. I don't want to be too cynical about it, because every now and again in the practice of the law you do get a case that involves fighting for an underdog, and that can be very satisfying work when that comes along. There are three, I think, life lessons to be learned from the movie. The first is the Dennis Denuto lesson, which is always be well prepared for court. And you'll learn that lesson from Mr. Denuto's hapless appearance at first instance. And the second life lesson is never underestimate the power of a good submission. It really is Hamill QC's submission, the one that I quoted from at the beginning in the High Court, that carries the day. And sometimes that can happen, and that's the importance of putting a case in a winning way, in a persuasive way, is obviously a very important thing. And it's really about having a think when you are involved in any case, having an actual sort of stepping back from the facts, stepping back from the law and thinking, what is it that I can say about this case that will make a judge want to find it in my favour? And that's a really important thing to move away from the detail in the practice of the law and think, how can I win this case? What can I say that will win this case? The third lesson, I think, emerges from Darryl Kerrigan's catchphrase, which is, how is the serenity? Or I think he says, what did he say? How is the serenity? Or feel the serenity? Something like that. And what I think emerges from that is that it's important for all of us to remember to stop and enjoy life as often as we can in the busy practice of the law, and make sure we try and make every day a good day if you possibly can. Now, I think, Nick, am I to introduce Greg? I think I'm to introduce Greg. It's my pleasure now to introduce Greg McIntyre, SC, who's going to say something about Mabo and the vibe. Greg is someone who, again, needs no introduction. He is a very prominent native title lawyer. He's been involved in many significant native title cases over the years. He's very well placed to say something about Mabo because he was a solicitor for the Meriam people from 1981 until 1992. And he also appeared as counsel for Eddie Mabo in the High Court in 1991. I suspect that, like all of us, Greg's also not beyond making the odd it's the vibe type submission, so he's probably well placed to say something about that as well. Thank you.
Dennis Denuto, as you can see from the slide, summed up the case by saying it's the Constitution, it's Mabo, it's justice, it's law, it's the vibe. And no, that's it, it's the vibe. Of course, Darryl Kerrigan chipped in and said it was the law of bloody common sense. And of course, what Darryl was adverting to was the common law. Unfortunately, the fictional federal court judges here didn't quite get Dennis's very simple submission. I mean, it illustrates the true art of advocacy. If you've got a complicated case, you make it seem simple. Dennis, I thought, did a very good job. Regrettably, the fictional federal court judge didn't get it and didn't understand what Darryl was talking about when he was talking about the common sense of the common law. All of the sitting judges I know would have immediately understood what Dennis was talking about. When he was talking about the vibe, he was, of course, quoting Lord Simon of Gladstone in Monsell and Ollins, which has been adopted by a number of High Court authorities, where Lord Simon said statutory language, like all language, is capable of almost infinite gradation of register. That is, it will be used at the semantic level, appropriate to the subject matter and the audience addressed. It's the duty of the Court of Construction to tune in to such register and so to interpret the statutory language as to give it the primary meaning which is appropriate in that register. That's what Dennis meant. I don't know why the federal court judges didn't get it. Of course, when he was referring to Mabo, they would have immediately known that he was referring to Mabo number 1 rather than Mabo number 2, because that was the case in which the majority referred to Section 10 of the Racial Discrimination Act and the Universal Declaration of Human Rights, which said that everyone has the right to own property, alone as well as in association with others, and no one shall be arbitrarily deprived of his property. Of course, that's an international human rights standard, which to some extent is reflected in our Constitution, Section 51, which speaks of acquisition of land, of property on just terms. Justice Kirby, of course, in dissent in Warrigal People, said, well, of course, just terms means more than monetary compensation. It means a great deal more than that. And in Mabo number 1, of course, what it meant was not only ought there to have been some compensation in the acquisition of lands, Declaratory Lands Act of Queensland, but there ought to have been prior notice in order to avoid the concept of arbitrary deprivation of property. Dennis, of course, when he was referring to the law, was clearly referring to the Magna Carta. Of course, it's our 800th anniversary this year of the Magna Carta, and Dennis and the federal court, any sitting federal court judge would have known that he was referring to chapter 29, which refers to no freeman being disseised of his freehold, but by the law of the land. Now, the castle, of course, is about one's home, and it is a long-standing tradition of Roman law, not only the common law that our home is sacred, and of course Marcus Tullius Cicero says it all there. What is more sacred, what more strongly guarded by every holy feeling than a man's own home? Sir Edward Coke also picked that up and spoke of a man's house being his castle. So you first start getting the concept of the castle. Et domus sua sique est tutissimum refugium. Each man's home is his safest refuge. Our mate Billy Blackstone, of course, picked up all of that. He refers to Cicero by his nickname Tullius, and picked up the quote which I just referred you to. But he let us know that the castle doctrine was really a doctrine about self-help. So not only is your castle safe to you, but you are entitled to use that law to protect your house from those who would violate it. That brings you to the situation in the United States. Adapted from all of that is the stand your ground laws, which exist in 20 states of the United States of America. There is a common law doctrine of the duty to retreat. So in our law, at least at present, in Australia, if someone accosts you in the street, your first duty at common law is to retreat. What has happened in the United States, in those 20 states of the United States, is that by statute, that duty has been abrogated and replaced by this stand your ground law, as it's commonly known, or more in Colorado they call it the Make My Day law, which is after what was said by Clint Eastwood in his character as Dirty Harry in a movie where he was in a cafe and there was a hold-up. An offender took somebody hostage, and Dirty Harry, in his usual style, pulled out a revolver after shooting up several people, and while the offender was standing with a gun at the hostage's head, he said, "Make my day," pointing his rifle pointing his revolver at the offender, suggesting that he was going to kill him in any event. That effectively is an exercise of the stand your ground defence, and it's allowed people to put up a defence of deadly force if they can say that there is an imminent threat of bodily harm. Now that's been played out in some of the cases which I have illustrated for you there. The gentleman in the middle is a man named George Zimmerman. Some of you will recall this case. It got a good deal of publicity. George Zimmerman was the neighbourhood watch man in a closed community in a county in Florida. He saw a young African American, 17-year-old, in a hoodie, wandering about the neighbourhood. He said he looked suspicious. He called 911. spoke to the police, said this suspicious-looking fellow is wandering around. They said, "We're coming, we'll be there in 5 minutes." He said, "He started to run, I'm chasing him," and he chased him. It then becomes unclear because there was only one witness left after the end of these events, and that was Mr. Zimmerman, as to what had occurred. The young man who was killed, Trayvon Martin, was on the phone to his aunt. He actually, within the closed community, he was living in the closed community with his father's fiancée, and he was speaking to her, and she said, "Come home," which is presumably why he ran. We then don't really know what happened. There was a trial. Initially, the prosecuting police officer, the investigating police officer, decided not to lay charges, as some of you will recall. There were investigations. There seemed to have been several investigations as to the way in which that matter should be dealt with. Eventually, an independent prosecutor was brought in and prosecuted, and the Florida jury found him not guilty. The Skittles image was an image which became a catch cry in the street demonstrations which followed the acquittal. What Trayvon Martin was carrying was a bottle of iced tea, a packet of Skittles, and a phone and a couple of other minor items. The suggestion of the protesters was that really that was the measure of his innocence, that he was merely carrying a bag of Skittles. And there are a number of satirical articles about the destructive qualities of Skittles. The next group of photos towards the bottom illustrate a case which is due for trial in August this year. It's an event which happened in February of last year when a retired Tampa police captain, Curtis Reeves, who was the older fellow towards the bottom, fatally shot a man named Chad Olson, who's the young man carrying his daughter, in a movie theatre in Tampa, Florida. Mr. Olson was texting his 3-year-old granddaughter's babysitter during the commercials leading up to the showing of a movie. Curtis Reeves got upset about that, complained to the management, then had an altercation with Mr. Olson. Mr. Olson threw his bag of popcorn over him. Mr. Reeves, as one does in America, pulled out his revolver and shot him. When I first read about this, I tried to work out what was happening in the trial. Couldn't quite work out what was going on. What I have worked out is that they're currently deposing 100 witnesses, all of the people sitting in the movie theatre. In the lead up to the trial will apparently occur in about August of this year. So watch this space as to what happens to Curtis Reeves. That all brings us to the current situation in Western Australia. I try to lighten it up a little by referring to the only home invasion movie which is not a horror movie, Home Alone. But there are 46 US states which do have the castle doctrine, which is as distinct from the Make My Day doctrine, is limited to protection of one's home. It's similar in terms to Section 244 of Western Australia's Criminal Code, which makes it lawful for an occupant in peaceful possession of a dwelling to use such forces as necessary to prevent the wrongful entry of a home, and that may resort to force which is likely to cause death to a home invader unless the occupant believes on reasonable grounds violence was likely to be used. So that's a rather sobering note. Fortunately, the film we're going to see is not quite so serious as that. And I should say that this fellow here, who was among myself and other counsel clearly satisfies Tom Percy's characterisation as an underdog who managed to agree to become the plaintiff and stick through it for a decade in order to get to the result we did.
Thanks everyone, thanks for your attention. Fortunately we only designated this as half a point, so we've nailed it. We've definitely done what we need to do. But there is some time if anyone has any questions for any of our speakers. Any hands going up? I often find the case with these things is the best questions are asked over a drink. We have our Barley Conference coming up. We have what we describe as the haze, which is a nice, not particularly obvious reference to drinking a few gin and tonics, and that often does generate some questions. Have we got any hands going up? No? Everyone wants the haze? That's very good. Help yourselves, do ask some questions, and have an excellent evening. Thanks very much.